Hi everyone, I am with Mr. Sharan Jagtiani, who is a Senior Counsel of the Bombay High Court, and he just got off a very interesting debate at the ADR Week on whether the courts must be allowed to modify an arbitral award or not. We're not going to get into the debate because the overwhelming majority of the audience said they should not. I am on the side that they should not, and Sharan was advocating for the side that they should not. But what I really want to ask Sharan is, what is the genesis of this problem? Like, why are we even discussing this? What are the challenges we are facing with ADR today?
I think that the principal challenge with ADR, though I feel that we're better off today than we were some time ago, but the principal challenge with ADR is twofold. One is efficiency, and efficiency has to be understood not only in the context of the efficiency before the arbitral tribunal, but also the time that it would take to resolve the matter at the court level, which is at the stage of a challenge to the award and appeals from that. That's one challenge. And the other challenge that we are facing also is one of certainty, which is in one sense a challenge which is endemic to all legal issues and disputes. But the problem why in arbitration it is more of a relevant consideration is because when people opt for arbitration, they're opting for a system which is meant to be outside of courts to get finality, and there is in theory supposed to be more accommodation for errors that the arbitrator may make, but you have to live with those errors. The problem with certainty is that at different points of time, there's been lack of clarity on what is really the room for error that arbitrators can make. But I think that on that, we're moving towards a regime where the law is getting more streamlined and the judges are a lot clearer because of the changes in law, that they will not easily entertain challenges to award. So whilst these two problems exist, I think that we're perhaps better off than we were before, and I'm more of a glass is half full than glass is half empty.
Hopeful for arbitration, given that mediation has come in, and that's...
I am hopeful for arbitration, but of course it requires more changes. I think that one of the areas on which there should be change, we as lawyers think too much about the changes at the court level, where the problems are really because there is a dearth of judges relative to the number of cases that they're hearing. And this is not just arbitration cases, it's cases per se. And there's only so much that the existing system can do unless you appoint or you have more judges. So that's one area on which change may be difficult to come by. But the area on which change can be done, and we as lawyers have to be accountable for that change, is that when we act either as lawyers or as arbitrators at the level of the arbitration, are we holding ourselves accountable? And the honest answer is, I think that many of us are probably not as efficient as we can be or as we should be, both in our capacity as lawyers and arbitrators. So rather than talk about the problems lying elsewhere, I think a little bit of introspection will also help in making the system better. And the one way that can be done is when you have domestic arbitrations done under the aegis of an arbitral institution like the MCIA or the arbitral institutions in Delhi, because they have a good set of rules. They have got very trained professionals who are regular full-time officers of those institutions. They can help to hold domestic arbitrators and arbitrations accountable to a higher standard of delivery, because ultimately we are rendering a service. And even if it speeds up the system at the arbitrator level, net you're still better off, and that does not require a larger systemic change of a better judge to population or judge to case ratio. So we can begin with that.
Yes, and on that note, thank you.
Thank you.
Perfect. Thank you.